Welcome to Wicked Lies, a podcast of how truth was destroyed by lies. Caution: podcast contains real people who were destroyed by wicked lies. For mature audiences only.
Hi, welcome to Wicked Lies. We are the podcast that tells the true story of people who have been falsely accused and or convicted in our legal system here in the United States. I'm Dawn Wolfson with Advocates for the Falsely Accused, and my co-host is Julianne Andrews. Today we're talking to Mr. Kenyon Clinton, who is incarcerated in Michigan for something he didn't do on a bad eyewitness identification. So Kenyon, welcome.
Hey, I just want to say thank you. You guys, on the platform to share my story.
You're totally welcome. So why don't you tell us how this happened that you got misidentified for a crime that you didn't commit?
Okay, well, I've been falsely accused and convicted for an armed robbery that happened on May 14, 2002 at 12:30 a.m. It happened in the city of Warren, Michigan, with a victim named David Cantrell. He was leaving a gas station. He was robbed of his personal valuables and things like that. Now, I'm totally innocent of the crime. I was not there at the crime scene. I actually presented a alibi witness. I passed the polygraph, and I presented an eyewitness identification expert recently that showed the identification was flawed. I was set up by the Warren Police Department and the Warren Police Detective Mark Christian. Now, how I get even contact with the police was that I was arrested on an unrelated crime associated with a vehicle that was supposed to be used in a string of robbery. And in this vehicle was a white Chevy Caprice that I was arrested in for an unrelated crime. Not knowing that the person, David Cantrell's property, was in the crime or what happened to him, any of those things, while I'm being arraigned for the crime that I was originally arrested for, the Warren police officer called this guy and told him, "We think we got the suspect that was involved in your case, and property of yours was allegedly found in the suspect vehicle that me and two other guys was arrested in." He instructed this guy to come down to the unrelated court date while we being handcuffed and shackled, sitting in court being arraigned for an unrelated crime, and have a show-up identification. And a show-up identification, for those who don't know, is when there is no lineup, there is no lineup fillers to protect the person for constitutional purposes, and it's a one-on-one situation where it's called a suggestive show-up. And so this person shows up, sees us in the courtroom. The detective calls him outside the courtroom, never making any of this known to the court while he was doing it, and said, "You seen some guys in the courtroom. Did you see the guy?" I said, "He's the guy." And he said that I was the gunman that, committed the crime against him. Now, what's ironic, Don and Julie, is that moments after the crime, the police arrived on the scene and spoke to the guy. And he gave an on-scene statement to the police officers. And he told the police officers that the suspect, who was the gunman, was 6 foot, 170 pounds, dark skinned. I'm not. At the time of my arrest, I was 5'10", 160 something pounds. I was medium complexion. I was 165 pounds medium complexion.
Right, and didn't this guy also say to the police at the time that there was no way he could identify the people?
Absolutely. He told the police officer that he could not identify any of the suspects as seen again, and that the gunman, the alleged role I've been convicted of, that he had a mask on. Now, this is why the detective never gave me a lineup, because he knew I didn't fit the identification. He knew the guy said he couldn't identify seen again, and he knew the guy said he had a mask on. The suspect had a mask on. This was the purpose of him setting up the show up to try to close the case. Now, what he didn't know was that there was other crimes that happened in that vehicle outside of Warren, Michigan. I was in Roseville. So when Roseville get the vehicle that I was arrested in, they found property from another crime in their car. And they put us in a lineup. And that lady said, "Well, these are not the people that committed the crime against me." and picked out a totally different person as the person who committed the crime against her, and found that person's fingerprints and DNA all over the property that was in the car related to her crime. But instead of the Warren Police Department giving me an identificational lineup, they knew that it was no basis to do so, so they set up the chief identification show up. And I was charged and convicted, and I had a Wade hearing on February the 26th, 2023. By the way, my case number is People versus Kenyon Clinton 02-2881-FC. That's the Macomb County Circuit Court case number where you can look it up and see everything that I'm saying is true.
Okay.
And at the Wade hearing, the judge stated that it was improper for that guy, David Cantil, to come to the unrelated arraignment. But he kept the identification in because he found David Cantil credible. Because David Cantil testified that, the gunman and none of the people had no mask over their face. He was able to see the faces the whole time and all of this. But then when we get to trial, he testified on page 48 that the gunman had a mask on, committing perjury. And the prosecutor herself admitted that there's only one witness. It's a simple case. It's an identification issue. But the problem is that back in 2002, over 24 years ago when I was locked up and convicted, the science hasn't evolved to where it evolved today. We know today, Julie and Don and the people that's listening, that wrongful convictions are, the leading cause for wrongful convictions are eyewitness identifications. And we know that to be true based on the science. It is based on science because
absolutely
DNA has shown, for instance, a guy could be convicted of first-degree murder and rape. And the victim is like, okay, I'm 100% sure it's the guy. This guy's on death row to be executed. But the DNA came back showing that it's impossible for this to be the guy. Now, in a court of law, a person like myself and others is faced with the question of either Mr. Clinton is the guy or the victim, David Cantil, is lying. That was the question posed.
Right.
Because back then, the science hasn't been evolved, but in reality, by David Cantil seeing my face at the unrelated show up, it contaminated the whole process. And now that transference from him seeing my face really got him thinking that I'm the person that committed the crime against.
Right. So he actually believes you're guilty,
Absolutely.
but you have a document by an expert that points out all the flaws with this eyewitness misidentification, right?
Yes, ma'am. Her name is, I have a world-renowned expert named Dr. Margaret Bull-Figueroa of John Jay College. She issued her report on May 10, 2023. And she stated that the post-event information from the officer telling this person that property is in the suspect vehicle, these suspects was being arraigned, it gave him the sense of that these are the guys. The police wouldn't tell me these weren't the guys, these got to be the guys. And so now, every time he goes to court and he sees my face, it's heightening up his confidence. And now they're confusing confidence with accuracy and reliability. See, the linchpin to it is not credibility. In his mind, he thinks he's credible, but he's not reliable.
Right.
And the first identification that he gave to the officer at the time who took his on-scene statement, minutes after the crime, that he couldn't identify anybody of scene again, that was the most reliable and accurate statement. How we know that to be true? Because he said that the person had a mask on.
Right.
So,
And he gave a completely different physical description also. And on top of this, you have an alibi witness. I mean, you were somewhere else and somebody provided a written statement to that effect, but unfortunately wasn't able to show up in court and alibi you.
He thought that I was going to be doing the trial myself, but he never any of my alibi witnesses filed the wrong name in the notice of alibi action. So when I get to the court, he said, well, I'm prepared to start the case today. And the judge forced me to represent myself. But since I was at the prison, I couldn't contact anybody. I have limited resources.
Right.
And to make matters even more clearer, my co-defendant, who was originally on the first case with me, it was his vehicle. It was his vehicle. He made a confession statement. It was his vehicle. He made a confession statement when he committed the crime in question against David Cantil that I wasn't involved in the crime.
So you have a statement from someone who was there saying that you were not there.
Absolutely. They didn't believe him saying that he was lying to get me off, even though my prints wasn't on none of the stuff that belonged to the victim in this case, or none of this stuff. And it's just baffling because outside of that, I had the prosecutor, he's the chief appellate prosecutor of Macomb County. His name is Josh Abbott. During an audio transfer phone call, he confessed that the identification was messed up and that the Macomb County prosecutor's office didn't want to do anything about it. You know, I took a polygraph showing that I'm not the person that committed the crime. I passed that. And also in 2003, the Macomb County prosecutor's office hired another doctor from John Jay College named Jennifer Dysart in the case of People versus Mac Howell. And they got the expert, and she said the identification was unreliable in his case, and they exonerated him and let him go. And now the thing is, I've been locked up a decade before he was locked up. So the question was, how was it do for him and not do for me?
So it was a similar misidentification, basically.
Yes. Mm-hmm. It would have been on and everything. Now in the state of Michigan created something called the State Bar Michigan Eyewitness Identification Task Force in 2012 and updated it in 2016. And the prosecutors of Michigan, the Prosecution Association of Michigan, PAM, adopted those same recommendations in 2016, showing that these criteria need to be updated based on the science for reliable identification. Now, in 2020, this is where a big shift came in, because Dr. Kovir was one of the 6 leading experts that was hired by the APA, the American Psychology Association, to update the 1998 white papers. And they included in this 2020 scientific consensus to avoid show-ups and to avoid repeated use identifications, both things that affected my identification and which is the cause that I'm in prison. So I filed a motion for the court to give me an expert, you know, as indigency. They denied it. So I get the money. I paid Dr. Kovira $7,500. I retain her, and she gives a report. They said that the report wasn't new, but Dr. Kovira's understudy, Dr. Dysart, report was new because the prosecutor went and hired her.
Mm-hmm.
Like I was so confused, and I never lost sight. I kept appealing up, and so January the 16th, 2026, People versus Clinton, the Michigan Supreme Court remanded my case back down to the Macomb County Circuit Court, seeing that the identification expert and the new scientific evidence was new. I get back down there. I have a hearing March 23rd, 2026. The trial judge denies it, don't give me an evidentiary hearing tonight. She does it in 6 days. So now I'm preparing to go back to the Michigan Court of Appeals. This time, hopefully, to get the case totally reversed and throughout. You know, and, I was able to get a team of lawyers called SATO, that's the State Appellate Defender's Office. And right now I'm being represented by Ben Mordecai Stronging and Annalise Finesses. Mm-hmm. And I'm very hopeful. You know, I'm very positive and optimistic because the Michigan Supreme Court think the same thing that I think. And they sent it to the trial court for them to fix it, and they failed to do so. So now I'm asking the Court of Appeals to take jurisdiction over the case and remedy this wrongful conviction.
Okay, so when is the hearing on
You
that?
have 1 minute remaining.
Go ahead.
Oh, sorry. So you've got a hearing coming up. When is that?
Finishing up the motion now. Then we're going to file a motion to get the actual hearing date, and I'll be filling you and Julie in on it.
Okay.
So you don't have a date yet?
Not yet. We're still putting the motion together because we're getting other evidence, we're getting other pleadings and things like that to make the case as strong as possible.
Okay.
And I will be calling right back in 15 minutes with you guys.
Yeah.
So welcome back. So you were telling us that you are waiting for a court date with the appellate court and that you were looking for some additional evidence. What other evidence are you trying to track down?
Well, looking at the mitigating factors, also in Michigan, they just, a case called People versus Eads came out, where they raised the age of juveniles up to 20. And at the time of the crime, I was 20 years old. They sentenced me to 37 years to 60 years, and I was considered a de facto life sentence. So not only are we going for actual innocence, we're going also for a reduced sentence, if anything else, to where I can be on the streets and fight it from the streets if necessary as well. So we have a mitigating specialist. Her name is Caroline Barron, and we've been working with all of these different people, to hit every angle, that we can possible.
Okay, and so you're going to the appellate court next. If the appellate court rules against you, are you going back to the Supreme Court?
Absolutely, and we are very confident that the Michigan Supreme Court, who granted the relief the first time, will look at it and see that the trial court and the Court of Appeals didn't follow their instructions and reverse the whole thing and suppress the identification, and now I'll be exonerated.
Okay. Julie, did you have any questions?
Yes, so where are the policemen and the ones that, convicted you, like the prosecutor and all that today? Where are they today?
So the police officer, Detective Mark Christian, he's retired. Then you have one of the prosecutors, Steve. It was three prosecutors. You had Bill Daly, who was the prosecutor during the Wade hearing, where the victim stated that nobody had nothing over their face. He's elevated and moved up to a higher position, actually. Then you had the trial prosecutor, Steve Kaplan, who stated it was one witness's identification case, and that's where Cantel testified at trial, where the gunman had a mask on and they didn't correct that testimony. He's now a prosecutor with the Detroit Wayne County Prosecution's Office. And then you had Joshua Abbott, the chief appellate prosecutor, who stated that the identification was improper and that nobody from the Macomb County Prosecutor's Office wanted to fix it. He is actually still in the Macomb County Prosecutor's Office, but I heard that he got demoted because of the conversation or admission that he made to me, but I'm not for sure, but that was what the rumors were said.
So what admission did he make to you?
I have an audio transcript, an audio phone call that I sent to you and Julie with a transcript of the call, where he admitted that the identification was improper. He said the identification was trouble.
Right.
And, he told me to write a 5-page letter to him, and he would take it to the head prosecutor, and he would advocate that the conviction needs to be looked at. But he said the head prosecutor, Peter Lacito, didn't want to do anything about it, and it was over his pay grade, but that he would take it and advocate on my behalf because the identification in the case was troubled. It was a flawed identification. And this happened in 2022.
So he's trying to do what's right, and you're saying he got demoted.
Yeah.
Absolutely. In trying to do what's right, he also has to protect his interests as well. Now, this same prosecutor, Joshua Abbott, while I filed my pleading in the Michigan Supreme Court, and the Michigan Supreme Court ordered him to respond, he filed a pleading stating that he was just being empathetic with me and this and that and the third. While he did make that fact that the identification was trouble, he stands by the conviction and this, that, and the third. See, he had to do that because his boss got to him.
Yeah.
But what they didn't know was that he was going to be recorded and his words would be used against him. His first piece of overwhelming evidence in the Michigan Supreme Court reply brief was that the gunman had on a mask. And my response to that was, well, that's not overwhelming evidence of guilt. That's overwhelming evidence showing that the identification was unreliable. And that's when the Michigan Supreme Court was like, Mr. Clinton is right, and reversed it and sent it back.
Okay,
There's
so
no evidence tying me to the case.
Yeah, there's no evidence tying you to the case, and you got an alibi witness. If she can ever be heard, is she still available to testify?
Yeah.
Okay.
And in fact, the lawyers from Sato and the investigators, they reached out to her and got an updated affidavit from her on my birthday. Actually, my birthday was July the 22nd.
Oh,
They
well,
got
happy
an
birthday!
updated affidavit from her. Thank you. And they got a new affidavit from her. She stood by the first affidavit, saying she was ready to come to court then. She's willing to come to court now. She knows for a fact I didn't commit the crime. I was hundreds of miles away from the crime.
Okay.
I was nowhere near the crime scene.
All right.
And,
so,
like I said, I passed the polygraph and everything, showing I didn't do it, and more importantly, the expert. The science. The court already accepted the science in the McHowell case, and it's the same Macomb County Circuit Court. So, I'm just hopeful. I'm very hopeful with the appeal, and I
And
thank you guys for allowing me.
is this the same circuit court that you're going to, or no, you're going to the appellate court? So it's not the
I'm
same
going to the
court.
appellate court, not the same court. When I went back to that court, they denied it again. A new judge who only had the case for 30 days. Never seen her, never knew, just got appointed, and she denied it within 30 days.
Okay.
All
right.
After she stated that she would look into it and gave the lawyers the time to file a brief and everything. And she just she denied her own order that was made on the record. It was like, it's crazy.
Yeah, that is crazy.
That is.
So right now we're waiting for a hearing, and is there anything else going on that you want to tell us about?
Can you come up for parole or anything?
Can I challenge the parole?
Can you come up
for a parole hearing?
Are you
Can I get a bail
eligible?
hearing?
Are you eligible at any point for parole?
No. See, this is why the case I was talking about when they just raised the age of a juvenile up, because in the state of Michigan, I can't see a parole board until I've done 37 years on a minimum.
Wow.
That'd be like in 2000. Yeah.
And you've
so
done
now,
what, 16 now?
Say that again?
How many years have you done now?
Over 24 years I've been in prison.
So another 13 years. Wow.
That is ridiculous.
Right.
That doesn't even fit.
Yeah.
That's not even a punishment that fits the crime.
Well, I was thinking that too. I mean, they give murderers less time.
Right.
Yeah. But
how does that
this
fit
is why
his
the ruling that
crime?
they just made in Michigan was so important.
Uh-huh.
They just passed a law in Michigan where first-degree murders can get 25 years on a minimum for juveniles. I'm serving more time than the person that committed first-degree murder, and I didn't even commit the crime, let alone murder or kill or shoot anybody.
Yeah. So
Right.
this reclassification of 20-year-olds, what does that potentially do for you? Does it reduce the sentence or what?
Yeah. It
Okay.
reduces the sentence to where you get potentially time served and
Okay.
hit a parole board and walk out.
Which is yeah. Which is better than nothing, right? But still, what you really want is to have this conviction overturned and to be exonerated because you didn't do it.
I didn't do it. Didn't do it. They offered me the plea deal.
Uh-huh.
If I would have took the plea deal, I would have been home. I didn't take the plea deal because I didn't do it.
Right.
Didn't do it.
Yeah, and you'd pretty much have to lie and say you did, which is outrageous.
And that's the reason they want everybody to take plea deals, because they want to say, yep, see, he agreed to it.
Yeah, and then it's harder to appeal.
Right.
All right. So Julie, did you have any other questions?
No. This case is just so horrific to me.
It is. It's terrible.
So horrific. This is exactly why we need to stop these plea deals, because this is horrific.
Yeah, I mean, they're taking people's constitutional rights away in order to get convictions is what they're doing. So Kenyon, we got a couple more minutes. Why don't you wrap up?
Okay. Just to be brief, last year my son was murdered.
Yeah.
May 3rd,
I'm so
2005
sorry.
at the Foot Locker. He was killed by that girl. And I could have been home to save my son's life, but instead I'm wrongfully convicted for a crime I didn't do. And being wrongfully convicted, everybody loses. I lost my son. The victim actually loses because he never got justice because I'm the wrong guy.
Yeah.
And society loses because the guy who committed the crime is probably out there committing more crimes.
Right.
So, and
you are exactly right.
It's the leading cause of wrongful convictions in the country, and it needs to be a legislative overhaul uniformly, because every court looks at it different, because judges and lawyers and prosecutors are not experts. They don't understand science. Experts are experts for a reason. The jurors don't understand experts. And so now the courts need to trust this science that they rely on. They sure relied on it in the Mac Howell case when the prosecutor hired an expert. But then when I go hire the expert over them on my own, it's not new evidence. And it's blatant. I've sent you guys the paperwork. I've sent you guys the proof to you, Don, to you, Julie. You know everything that I'm saying to you can be proven factually. If the people want to see it, we'll be putting up a website where they can go and see these documents. If anybody want to reach out to me, my name is Kenyon Clinton, MA number 364567. You can reach me via JPay, that's W. The letter J, the word pay, PAY.com, and email me, or you can write me at Macomb Correctional Facility, 34625 26 Mile Road, Lenox Township, Michigan, 48048. For any support or questions or anything that you might have any concerns with or issues about. And I really just appreciate you guys.
All right. Well, thank you so much for telling your story. It's horrible. I mean, you're absolutely right. They just destroyed your life, and the person who actually really did this is still out there, which is just awful. We will get your story out there, and thank you so much for talking to us today.
Yes, thank you.
Thank
We
you
will
for,
get your story out there.
Thank you so much.
Thank you for listening to Wicked Lies. If you would like to learn more about advocates for the falsely accused, join us at www.theaffa.org. That's www.theaffa.org.